thank you. I'm very happy to be here. And of course, I would like, first of all, to extend my gratitude to Julita for her kind invitation to this panel. As it was briefly introduced, as it was briefly introduced, I will now deal with the Court of Justice of the European Union case on Meloni. So this is a very important, I am Spanish, and this is a very important Spanish case, which was dealt with both the European Union by means of a preliminary ruling and at the Spanish constitutional level. And I think it is especially interesting in terms of national sovereignty and the title of the panel, precisely because, of course, due to the European integration, states kind of provided a little bit of their sovereignty to the European Union to make this possible, but that doesn't mean there should be no room for this national sovereignty to remain with states. And sometimes we can find clashes between how to interpret EU law at the national domestic level. So, of course, the principle of primacy, also refers to precedent supremacy of EU law, is one of the cornerstones of European legislation. And it is based on the idea that when there is a conflict arising between an EU law and a national provision, the EU law should always prevail. However, as I was introducing, there has been some cases where this has been a sensitive issue, since the national constitutional courts have to act both as European and national judges. This means that there are cases where they reach the constitutional level and the constitutional court has to somehow interpret some EU legal provisions. And this has become, in the last years, a very sensitive issue because of this interpretation and this duality of the national constitutional judge role. This is due to mainly two factors. First of all, because the legal order of the EU and the legal order established at the domestic level by each of these member states are distinct. And for instance, in the particular case of fundamental rights protection, there may be instances where either EU law or national law provide for different standards. And on the other hand, we have that maybe sometimes, while the legal order is founded upon these principles of primacy, effectiveness, unity, national provisions can establish to which extent this EU law is applicable and given precedence over their own domestic law rules. So sometimes these national provisions may even act as a limitation to EU legislation in terms of fundamental rights protection. So given these two factors, there may be some incompatibilities arising, some conflicts arising, which may be of two kinds. The first one is that this fundamental rights protection is higher at the EU level than on the national level. Here, there is no issue because we apply the principle of primacy of EU law and just it is applied. So this more extensive approach, this more extensive standard of fundamental rights protection is applied even if this national constitutional law provides for a lower standard. But there is the contrary case, where the domestic provision provides for a higher standard of protection than the EU law. And here, it's when the Meloni case comes into play. Because if we strictly apply the primacy of EU law, this should not happen. The EU law does not permit it. So now let me briefly introduce you the case and the facts so we can comment on it and how this has shaped afterwards the Spanish constitutional approach to interpreting EU law. As I was mentioning, this is a very important case for Spain because it was the first ever preliminary reference made to the Court of Justice of the European Union by the Spanish Constitutional Court. It was back in 2011. And it deals with a direct clash between these national constitutional rules and the EU law, concretely the decision framework on the European arrest warrant, in terms of procedural rights in the context of a conviction in absentia. It is a landmark case with respect to this sort of rights, and now we will see why. It's called Meloni case because the main subject of the case is Mr. Meloni, an Italian businessman who was convicted in Italy was first prosecuted for bankruptcy fraud and tried to escape the Italian justice by moving to Spain. Back at the time, he was able to hide, and he, even though was aware the time and the day where his trial was being held in Italy, he decided not to attend and just sent over his lawyers to represent him and defend his interests in court. He was then sentenced to a 10-year sentence of imprisonment. And as soon as the judgment became final in 2004, Italy issued a European arrest warrant towards him to Spain to surrender him. In 2008, the Spanish police finally got him, but he refused the surrender, and he even went farther to say that his right to a fair trial had been violated because they delivered the judgment even though he was not present at the court. It was held in absentia. So given the fact that he was not going to surrender, that he didn't really like the outcome of his judgment, he decided to submit a petition before the Spanish Constitutional Court. We call it in Spanish recurso de amparo, and it is a petition on the most because there has been a breach of one of the most fundamental rights that we have in the Constitution, which in this case is Article 24 on the right to a fair trial. So he basically claimed that, and he was then and then the Spanish Constitutional Court, when examining precisely this European arrest warrant, the draft, the decision framework, which was amended in 2009, they clearly saw a struggle. Because in the Spanish, according to Spanish law and according to the own Spanish Constitutional Court case law, they had some doubts regarding the favorable outcome of this judgment, and they decided to submit a preliminary reference to the Court of Justice of the European Union in 2011. Because according to the Spanish law, there were some doubts regarding this outcome in terms of him being in absentia. So the Spanish law provided for a higher protection than the actual European arrest warrant did, according to which this judgment was completely fine and he was just to be surrendered to Italy. So this order contained 3 questions. The Spanish Constitutional Court asked whether the concrete article, which was in conflict, was to be interpreted as such, then if it was valid in light of Article 47 and 48 of the EU Charter of Fundamental Rights, which deal once again with the right to a fair trial, and the most important one, if under Article 53 of the Charter, this could be granted a higher level than protection than the one granted by EU law. So applying the level of protection granted by the Spanish law rather than the EU law. By judgment of 26 February 2013, the Court of Justice of the European Union answered favorably to these 2 first questions, but regarding the last one, they said that this was not possible, that we could apply national constitutional rules, but only when the EU law called for a national implementation. In this case, this was a harmonizing provision, so this was not possible, and the European arrest warrant article should be implemented instead of the national one, which was not something the Spanish Constitutional Court did like much. And by judgment of 13 February 2014, the Spanish Constitutional Court, even though they were not very prone to this judgment, they reversed its own case law to square it with this EU law. But they did it in a way that didn't really expressly line up with the interpretation the Court of Justice of the European Union had given to Article 53. And what is interesting is that it was an anonymous judgment, but it had 3 concurring opinions, and 2 of them, the first ones, they were even more favorable to the Court of Justice of the European Union judgment than the Spanish Constitutional Court judgment itself. But something about the third concurring opinion that was very interesting to me, and I really agree with it, is that according to Justice Andrés Ollero, instead of being a judicial dialogue, it was just like a father telling their child what they have to do, without really asking why or trying to find common approach to it. So they say that this hadn't necessarily been given a sense of a monologue where assent is compulsory. And I think this is why the Spanish Constitutional Court really received very well the judgment of the European Court of Justice. Of course, the outcome was that aside from reversing its own case law, the Meloni ruling shifted the balance of constitutional jurisdictional power in favor of the Court of Justice of the EU instead of the National Court. And this led, and this is interesting because this case was from 2014, we're in 2024, and during these 10 years, the Spanish Constitutional Court, given this judgment, has not submitted any other preliminary reference in terms of fundamental rights to the Court of Justice to avoid this conflicting situation. Instead, what they have done is when such a case arrived at the constitutional level, they just tried to solve it and interpret it in a way that was kind of solved with the constitutional rules. So no question had to be submitted to the European Court of Justice, which is of course a pity when we are dealing with the European Union and such constitutional pluralism, as I mentioned in the title of my presentation. And also as part of my conclusion, I have to say that this has been an inspiration for some other states to take this nuanced approach, but some other states have gone even farther as to oppose directly what the Court of Justice of the EU interpret in some instances as the Federal Constitutional Court of Germany, which sometimes has, in some of their judgments, they have said that the interpretation of EU provisions by the Court of Justice of the EU sometimes has gone ultra vires, and they have defended their own national identity and their own national identity review of their provisions. So during these last years, I believe that we have been witnesses of a revitalization of this debate on the principle of primacy between EU law and constitutional law and the national sovereignty that we were talking before. And even though these sort of conflicts are very rare, when they come up and we are faced with such conflicts, it is really testing the limits of European integration and the well-functioning of the European Union. So in my opinion, when we face such conflicts, we should try to avoid them or minimize them through finding convergence and common approaches to it, which is what the 2 first concurring opinions to the Spanish judgment mentioned, that it should have just tried to find a common approach rather than just taken that nuanced approach and a little bit not ignoring, but not really implementing what the Court of Justice said. And again, we have this other type of cases where the national judge just disobeys and confronts, and that is a pity again. And in my opinion, that is legitimate, of course, but should only be considered in exceptional cases and as a last resort. Because for me, the option, the most important idea of European Union integration, that something that we should always try to look for is judicial dialogue across the EU and this convergence and common approaches to it. Because otherwise, as I said, it's just one father telling their child what to do, and that has nothing to do with constitutional pluralism and with any of the purposes of the European Union. So thank you very much, and I look forward to answering any questions if you have them.